and we will go ahead and call the first one, People versus Robert Taylor. This is a 15-minute mini oral argument on the application. That means, Mr. Dugan, you have 15 minutes. You can try and reserve some of that, but as you know, we like you to try and do that yourself. And when you're ready, you may proceed.
I do know that from watching the videos, Your Honor. Good morning, Your Honors, and may it please the court. I'm going to try to reserve 2 minutes. Conor Dugan on behalf of Robert Taylor. This case presents the court with an opportunity to provide clarity to the prosecutors, defendants, and states of this state of how to apply the Miller mitigating factors. To that end, I'd ask this court to grant, reverse, and remand and make 3 things clear. First, the burden on establishing that a child should be sentenced to life without parole should be on the prosecution. 2, the Miller mitigating factors are true mitigators. They cannot be used as aggravators. And finally, the trial courts must engage in individualized sentencing regardless of the defendant being 17, 15, or 13. Mr. Taylor's case highlights some of the problems that courts have struggled with in the 10 years since Miller in applying these factors, and that's why this court's guidance is sorely needed. In particular, I point to the trial court's almost identical verbiage that it employed in sentencing Mr. Taylor and his co-defendant. Its failure even to engage the statement from Mr. Masalmani that Mr. Taylor was not aware of or involved with what was going to happen to Mr. Landry. And then third, the use of Mr. Taylor's home and family background as a reason to sentence him to life rather than looking at it as a mitigating factor. If I might turn first to the burden question, I think the straightest line here is the typical burdens that we place on a moving party. And when we have such a fundamental Eighth Amendment right at issue, it makes sense under MCL 769.25 to place the burden on the prosecution. In terms of the mitigators being actual mitigators, that was clear in this court's decision in Skinner. The trial court didn't have the benefit of that decision, and you could see how it fell into error in several places where it used those factors to aggravate. And then finally, the question of individualized sentencing. That was clear in Montgomery and Miller, and Jones didn't change that. And here there were several things in the trial court's opinion which showed that it didn't engage in that. I would also ask the court to consider whether or not, after 10 years of the Miller and its progeny, whether or not even these clear standards that I've just set out make sense. 2 days ago, Michigan celebrated the 175th anniversary of being the first English-speaking nation to ban the death penalty. Unfortunately, we see now, especially in the Juvenile Justice Clinic's brief, that we are on the other side when it comes to LWOPs. I'd ask this court to consider the categorical ban and take up Jones's invitation to see what the Michigan Constitution requires. If there are no questions, I will reserve the rest of my time for rebuttal.
No questions?
I have one. I can't let you sit down without a question. I mean, why you came all the way here. Would you agree, I see your point about that the factors clearly have to be mitigating, not aggravating. But do you think that the extent of mitigation does depend upon the age of the defendant? So it's mitigating, but it is still, the extent of that mitigation could be determined based on, how close they are to 18 or how old they are.
I would resist saying yes to that, Justice Cavanagh, for this reason. I think Miller sets a bright line that says anyone under this line, the court needs to engage in individualized assessments. So you certainly could have a more mature 17-year-old or someone whose circumstances, who's 17 and 364 days, show that he or she is impetuous, had horrible family circumstances. So I think it still requires that individual assessment. So I would resist saying yes to that.
Okay. Okay, thank you.
Counsel, I do have a question as well. If we were to agree with you that there
is a presumption against life without parole, and that the prosecution bears the burden to overcome that, as I know some other states have done. How do we mesh that with our decision in Skinner and the Supreme Court's decision in Jones?
Yes, so I've done a little thinking about how we mesh it with Skinner. I think Skinner, as I understand it, said because, first of all, it said that Miller and Montgomery didn't establish presumption, which is true, but there's a difference between presumption and burden. Secondly, because the fact of conviction allows the juvenile to be sentenced to life without parole, there would be no fact-finding that would be required to enhance the sentence. So I don't think the tension is quite there. I certainly worried about that as I was thinking through the case, but I don't think it's there. And I certainly don't think Jones touches that. I think Jones was a very discrete issue, looking at the question of whether or not a specific finding of irreparable corruption or permanent incorrigibility. And I think really about whether or not those magic words were required.
Thank you.
Thank you, Your Honors.
Good morning. May it please the court. Emil, Semaan on behalf of the people. I will waive my free fire zone for the questions. Thinking about this case, one of the important things that came to me was really the burden of proof question, the presumption question. The issue that I came out to and how I struggled with it was, who should have the burden of proof? Should it be the defense or the prosecution? And I would submit that to give either the burden of proof is a very dangerous concept to the sentencing considerations. If brother counsel's argument regarding the mitigation factors of Miller are to be true mitigation, it would be illogical for the prosecution to have the burden, because then we would have to basically prove that he should be mitigated into a non-life without parole. We wouldn't want to. Why would we? We would simply stress the heinousness of the crime. And the argument would simply be, how's his home life? Fine, prove me wrong. There would be no reason for us to want to mitigate. And even with the Miller and the Montgomery, even Montgomery seemed to put the presumption on defense, on the defendant to prove mitigation. I think that would be very dangerous too. Because brother counsel and I are part of an adversary system. We will always have what is considered blinders. I, as a prosecutor, or any prosecutor, will advocate on behalf of the victim. Justice for the victim. The defense is going to advocate on behalf of the client. He is capable of rehabilitation. No one knows him better than I. But the judge, the sentencing judge, has a higher purpose. They consider other factors. They don't just consider rehabilitation. They consider deterrence, protection of society, following the laws of the state and the country. These are the considerations, and they do it as an impartial and neutral observer. They do it to keep balance between both sides. Because allow both sides to have their day to persuade the court it should be this sentence or this sentence. The idea is the judge has to make the decision considering all the factors that we will not, because we are only considering our client or our victim and what is best for them and what is best under those rose-colored glasses, what would be best for society.
Well, but the juvenile gets a term of years unless the prosecution files a motion for a life without parole sentence, right?
Yes.
Can you give me an example of another situation in which a movement does not bear the burden of the burden of proving that they're entitled to the relief that they're filing a motion on?
Self-defense. Probably the closest one I would think of, where they bring some evidence of self-defense and the prosecutor must disprove self-defense. So that burden is on us because the idea is a defendant is presumed innocent. And the presumption is that he is presumed innocent unless we show beyond a reasonable doubt he is not. Now consider insanity. They are presumed to be sane and competent unless, but once that shows, they then have to prove that they are not. Here, the presumption under the statute for murder, first degree, or felony murder is life without parole. They've now created an exception under Miller saying that before you can do it, same we did as Lockridge, there's no mandatory life without parole, as well as there's no mandatory sentencing guidelines to cure the constitutional error. Therefore, now the issue is, Since there's no mandate, we make it advisory or we make an exception. Miller made the exception to the categorical mandatory life without parole. The exception is there's allowing for mitigating evidence to then consider an indeterminate scheme. And 769.25 allows that. Now, they've also added the prosecution must move. To, in my opinion, take it for what it's worth, is to give basically a streamline. If the prosecution is not going to move for life without parole, then the sentencing court has a much easier situation. Why deal with all this? Just let's go to a sentencing of indeterminate scheme. But it's to, I think, to make some efficiency in the courts, not so much to create a burden of proof or a burden of persuasion or a burden or a presumption of either. Because even Montgomery, Miller, and Jones seem to show that there was no, basically said there is no presumption against life without parole. There is no categorical bar to life without parole. The only idea here is there a way for him not to get life without parole? Are there mitigation? And who is the ultimate finder of that? The trial, the sentencing judge. They have that ability and they have that duty. Even every appellate review we look at, it's not whether or not the prosecutor had to prove it should have been an upward departure or the defense had to prove it should have been a downward departure. Did the sentencing judge justify its departure? Because assume for a moment, one of the thoughts I actually had that concerned me is, let's assume the burden was on the prosecution. And the argument came down to, I write a wonderful brief, I'm so amazingly persuasive that the judge agrees with me that it should be life without parole. And then, but he agrees, but for other reasons that really have nothing to do with Miller or my reasons. And on appellate review, the court could say, which I've heard 100 times, say, you're right, the judge made the wrong reasons, but he reached the right result because the prosecution made the burden of proof. That could be a very dangerous proposition to a defense and vice versa.
Let me just ask you about the trial judge. What should we make of the trial judge's use of the term favors? That the Miller factors favor life without parole. Is that suggesting that the trial judge was using these factors not as mitigating factors when they use that term?
No, I think some of the Miller factors would favor and some mitigate, right? The heinousness of the crime, the more heinous, that would favor life without parole. Less heinous would militate against it. Home life could mitigate against it and some would favor it. I think that would be probably the best interpretation of what Judge Drzezinski was trying to state in that matter.
But do you agree that the Miller factors are only mitigating factors?
I think the line between mitigation and non-mitigation is very thin. And that's why I gave the example of the heinousness of the crime. You look at a crime where I think one of the arguments yesterday with one of the individuals was the person was the getaway driver who didn't shoot anybody. And while the crime was heinous against the person who committed it, that individual probably had less culpability than the main individual. Then you can look at the other end where the person who was the shooter was more culpable, who maybe committed, like in the facts of this case, like Mr. Malsamani, extreme behavior into this matter. So based upon that, the heinousness of the crime would not mitigate in Malsamani, but maybe another one, it would mitigate.
So you'd have us read favors as really the judge is saying does not mitigate.
Does not mitigate maybe for that specific incident.
Yes, this
for that
Miller factor
individual.
does not, this is not a mitigating factor under Miller.
For this individual person.
Yes.
What do we do about the fact that the judges almost, I mean, the transcripts of both sentencing or for both analysis is almost, I mean, it's so similar for both Mr. Malsamani and Mr. Taylor. And they received the same sentence and the same sort of analysis, whether you consider it being used as mitigating or aggravating. And clearly, I mean, they have different roles to play in a horrible crime, right? How then how are we supposed to review the judge's finding that it's truly the rare individual, the rare juvenile who, is deserving of a life without parole sentence when there are clearly differences in this particular case between Malsamani and Mr. Taylor?
Well, I would say the differences are overshadowed by the similarities between the two. This is not a situation, as I say in the cases yesterday, where you have an individual who is the main shooter, goes in and shoots somebody and takes their things, and the person who's the getaway driver who wasn't even in the store. Here, everything with Mr. Taylor and Malsamani was intertwined. They both together took the victim. The facts show that they took him, they put him in the car, they took him, they used his cash. They murdered him, and then they left him there. It was so intertwined to say this person was part and parcel all the way through. There was no evidence shown that there was a thing where he helped Mr. Mazlamani put him in the car and then disappeared for a while, or was not there at the rest of it. The evidence showed he was there part and parcel for every part of it. So because it was so intertwined, because of the specific actions of both defendants, it's not the normal getaway driver and murderer that you would have, or aiding and abetting in the idea that the person was simply there with no gun and didn't have anything. It was so enmeshed that it would be very difficult for any sentencing judge to distinguish between the two to the best she can. And she did make some distinguishing between the ages, between the home life, but also in the idea that when it came to the crime, being so enmeshed, it would be very difficult for anyone to just as easily separate them.
Okay.
Counsel, I have a question. I guess this goes a little bit to the burden piece. In this case, the trial court found the defendant didn't present evidence that he'd be able to be rehabilitated. And I'm wondering how a defendant could ever satisfy that. How do you ever prove that you can be rehabilitated? They presented experts, of course, on how rehabilitation works and how it's often successful, but that was not found to be a factor helpful to the defendant in this case. And I'm wondering, how would that ever work?
I think that would, if I had a wonderful answer to that, I'd be a very rich man at this point in my life, probably running for government. I think it would. There are some possibilities that you have. For example, some of the things that they look at are the misconduct, if there was any misconduct in jail or prison at the time in between. Sometimes, depending on the expert, maybe there will be tests that they can utilize to determine, based upon that psychological test, maybe a psychological screening that could help with that. I don't know many of the different ways that would possibly allow somebody for rehabilitation. But I think what you also had was Dr. Keating had very trouble with showing, or was it Dr. Keating, or the doctor expert had trouble arguing that that any rehabilitation would be much more difficult when you purposely take someone's life. So to show rehabilitation, are there ways? Sure. Are they taking counseling while in the jail? Are they doing something while in the jail? Have they maybe a spiritual advisor is helping them while they're in the jail? There are different ways to show that. There are the same ways that you have with, and I'm not trying to mitigate it, to diminish it, but think of drunk driving cases. How do you show that this person will never be a dangerous drunk driver? You get a substance abuse analysis. Maybe you start going to AA on your own. You do things to show the trial or sentencing judge, look, I'm going to make it better. I'm not going to do this. Same with drug addicts. I am putting myself in NA. I am taking counseling. I'm trying to stop my downward spiral. Even a juvenile who is charged with murder, there are still things they could do. There are programs in the jail, there are programs in there, there's spiritual advisors, there's counseling they can do to show, look, I'm trying to make it better.
Is it limited to the time between arrest and sentencing, or can you also consider pre-crime activity?
Yes, you can consider pre-crime activity. You can consider how they evolved, if there was an evolution of crime, so to speak, or criminality. If they started with somebody who simply stole a candy bar from a store and then jumped right to murder, then maybe there is some question that this is not, there could be some situation of rehabilitation. We haven't seen a serious case. And you have another case where an individual could have started by burning cats, then killing cats, then assaulting people, then murdering people, and then you have where you are now. So I think rehabilitation will require a totality of circumstance, looking at everything. And the question, I guess, going to the burden of proof of who could produce these kinds of information, should it be on the defense or the prosecution, which goes to burden of proof, is the burden of production. One of the arguments would be who is best to provide this production. Some of the mitigating would be best by the defense, because I don't think any defendant or defense attorney wants a prosecutor interviewing their client after a conviction and trying to get into all the different things of their life. The actual fairest way, I thought about this last night, the fairest way to get a lot of this mitigation in is, honestly, to potentially change one of the court rules and to make it a requirement in the PSIs that probation must prepare for the judge, because it's the judge who must make the decision.
Counsel, I have a question.
Yes.
This case is almost like biblical in its nature, in terms of the horrendous nature of what occurred and what happened. And, I've just, this is one of those cases you really don't stop thinking about. And I just kept thinking about the perspective, and I'm going to get to this question very quickly, but I'm going to think of it from this perspective, right? This was just a really young, nice hockey-playing kid, comes out of a Quiznos, and basically I just keep thinking about what he, the experience this young man must have had being in the trunk of a car. I mean, the things that he must have heard and the feelings he must have had, and that emotion that comes from a person having to literally beg for their life and then have their life not be spared. And I guess what I come to on a lot of this is I understand we can talk about the factors and we can go through this, but where I struggle with this is, are there just some people who can't be rehabilitated? And that ultimately, when you get to a certain, you take certain actions, you do certain things, then you know what? That's it, right? You're that horrendous, you're that heinous, you allow for something so horrific to happen to another human being that perhaps, at this point, I understand what the Supreme Court is, I get all of that, but perhaps that's what the trial judge was getting at.
I think that's part of it, that there are people beyond rehabilitation, but I think you also look at the fact that this boy will never be paroled, will never be alive, will never be here, and his family is gone. And when you have such a heinous crime, you are having the most significant crime we have in our system. And not only do we look at rehabilitation and deterrent, but we look at the protection of society. Because if not, if the idea is you murder someone in the most heinous way you can think of, and then you shouldn't be punished as much as we can to protect society and to uphold the rule of law, then we basically would say it's free range for anybody to go ahead and throw somebody in the trunk of a car, take them to Detroit, shoot them, and leave them to death, begging for life, when the whole idea is you're under 18, you get a pass. That can't be the rule.
Well, but isn't that in fact the rule that Miller says?
No,
I
Miller said that there is mitigation to it, and you can't automatically, you can't
Right, but
automatically
we're dealing
give
with a
life.
category of defendants who, we're in this realm of horrific crimes and horrible behavior by defendants, the worst crime, right? So, and we can't, once we're in that category, we have to, Miller says you have to look at, because there's a reason for juveniles under 18, that they're not as morally culpable, and they have a greater potential for rehabilitation. We're in that realm, so I don't, and the heinousness of the crime would be a blanket rule.
I'm out of time. May I answer the question?
Sure.
You may.
Thank you. I'm not trying to say that that's the blanket rule and that's the only consideration, but what I am saying is Miller did not create a categorical bar. And the U.S. Supreme Court could have created a categorical bar. They did it in Roper. They did it with juveniles being executed. And they could have said no life without parole. Mm-hmm. What they did was say you can't automatically give life without parole before considering these factors. So they wanted to say, sentencing judges, you have discretion. Even in Lockridge, we gave the same idea. You have discretion, give the reasons why, and these are the reasons that we ask that you look at, whether it was Milborn or whether it was Miller factors. But whether there's a presumption against life without parole, I would say Miller Montgomery has stated in the brief, and Skinner does not really say that there's a presumption against life without parole, but that it cannot be automatically mandated without considering the factors and considering that the fact that there may be an indeterminate sentence that may be better or required here.
Okay.
Thank you, counsel.
Thank you.
Your Honor, just a few brief comments and rebuttal. First, to address Justice Cavanaugh's last point, all of these crimes are going to be heinous. That's the nature of Miller, Montgomery, and Jones, and so that they will always involve heinous crimes. And Justice Bernstein, you asked about people not being able to be rehabilitated. That may be the case, but I think we need to be clear that if the court sends this back or adopts a categorical rule, we're not opening the prison doors. We're simply giving a chance for the system to see if it can work to rehabilitate. It may be the case that many, all, may not be able to be rehabilitated. Justice Welch, you asked about the finding of the trial court on rehabilitation, and I think that point illustrates some of the issues here with the trial court's decision. It said my client hadn't proven that he could be rehabilitated, yet then on the other side, it used the fact that in the past he had had bad family circumstances as proof that he couldn't be rehabilitated. So somehow it was clairvoyant about that, but not about the possibility of MDOC. And then I wanted to address the other point of Justice Cavanagh about burden shifting. My opposing counsel talked about this statute, MCL 769.25, perhaps just being about efficiency. The legislature could have said that, it didn't. And I think against the backdrop of our normal burdens, it makes sense that the prosecution should bear that burden. And then finally, Justice Zara, you talked about whether or not I think there was language in the opinion about favoring and not favoring. I'd also point to language where the court said this particular mitigating factor was chronological age and hallmark features does not weigh as heavily against defendant as it did. So I think it was more than just saying this favors and maybe this mitigator isn't present. It was using the mitigators as aggregators, and that is what this court said can't be done in Skinner. There are no further questions.
Do you have a response to counsel's assertion that if there is a burden required, that he gave the example of meeting the burden and the judge making a decision on other reasons, but saying the prosecutor met their burden, so they win. I mean, is that a concern? Do you see?
I don't think it's a concern, and this is a question I've thought about a lot, Justice Clement. The prosecution can show that there were prior offenses, could show that the prison record of the particular defendant shows that he or she's incorrigible, could talk about prior involvement with law enforcement or other offense or subsequent acts. So I understand his concern about prosecution having to prove mitigation, and that seems kind of strange, but that's not what the burden would be. The burden would be to show these other things that show this person is in that small category, that rare category of being incorrigible or unable to be rehabilitated.
Okay, thank you.
If there are no further questions?
I have a question,
Oh, sure.
I have a comment. Both of you did an excellent job. I want to say to you, Mr. Dugan, that was a very good rebuttal, an excellent rebuttal. When you had 9 minutes left, I thought, well, he's going to save the 9 minutes and try to ambush after prosecution did their thing. But you came up here and you addressed every single question we had, and it was a textbook rebuttal. So both of you, fantastic job.
Thank you.
And one of the best rebuttals I've ever seen.
Thank you. Thank you. Appreciate it.
Thank you.
Thank you both. The case will be submitted.